Hi, my name is Kaylee Antolik, and I am going to be presenting my presentation on testamentary capacity, understanding legal and clinical perspectives. A concept at the intersection of psychology and law that's critical when evaluating whether someone is competent to create a valid will. We'll look at definitions, legal standards, how psychologists assess capacity, and how it plays out in real cases like Brooke Astor's. So in this introduction, we're going to be asking, what is testamentary capacity? Why is it important in law and psychology? And Melton's key legal and clinical criteria. Testamentary capacity refers to a person's legal and mental ability to make or alter a valid will. This concept matters because legal disputes over wills often depend on whether the person truly understood what they were doing. Psychologists play a key role in these evaluations, particularly when the individual has signs of cognitive decline, and will be guided by standards outlined in Melton's text. Definition of testamentary capacity per Melton is that they understand the nature and extent of their property, recognizes the natural beneficiaries, understands they are making a will, can create a rational plan for asset distribution. According to Melton, there are 4 essential elements that must be satisfied for testamentary capacity. The testator must know what property they own, who should logically receive it, understand they are signing a will, and must be able to make a consistent, rational plan. It's a legal threshold, but one that intersects deeply with clinical judgment. Low thresholds of capacity would be legal standard is intentionally low, mild cognitive impairment does not equal incapacity, and focus on is the mental state at the time of signing. It is important to remember that the legal threshold for testamentary capacity is intentionally low. Even individuals with early onset dementia or mental illness may still be considered competent as long as they meet the criteria that the specific time the will was executed. Clinical assessment of capacity per Melton is often retrospective, done after death, interviews with witnesses, medical and psychiatric records, and a timeline of events. Capacity assessments are often retrospective, meaning that they take place after the person has passed away. Forensic psychologists piece together evidence from interviews, medical documentation, and witness statements to evaluate the testator's state of mind at the time of signing. Lucid intervals and mental illness. Lucid interval is a temporary return of clarity, whereas mental illness is not necessarily equal automatic incapacity. Each episode must be evaluated independently. A person with serious mental illness or dementia may still have lucid intervals, brief periods of clarity, during which they can make decisions. Capacity must be evaluated based on the person's mental state at the exact moment, not their overall diagnosis. The role of the psychologist is that the psychologist assess is a short-term memory and reasoning, presence of delusion or hallucinations, signs of cohesion or undue influence. Forensic psychologists assess key cognitive domains like memory and logic, while also watching for red flags like delusional thinking or pressure from others. Their job is to determine whether the will was a product of the individual's free and rational decision making. Undue influence versus lack of capacity. Lack of capacity is internal cognitive limitation. Undue influence would be external manipulation. An example would be an elderly woman with mild dementia signs while leaving everything to her caretaker. It's crucial to differentiate between incapacity and undue influence. Incapacity is about the testator's mind. Undue influence is about outside pressure. In legal settings, both are grounds for contesting a will, but they require different types of evidence. Some media examples, like the Brooke Astor case, is disputes over mental capacity, allegations of undue influence by the son, and a psychiatric expert testimony. The case of Brooke Astor is a real-world example where testamentary capacity and undue influence were center stage. Her son was accused of manipulating her into changing her will. The court had to weigh expert testimony to decide whether her decisions reflected her true intent. For our discussion question, should a person with mild dementia who appears lucid at the time of will creation be presumed competent? What factors should we examine, and how does Melton's guide help us with our case? This discussion question invites us to think critically The law presumes capacity unless proven otherwise, but in borderline cases, we must apply Milton's criteria carefully. Consider not just the diagnosis, but the person's actual abilities, reasoning, and independence when making decisions. A person with mild dementia who appears lucid at the time of creation should not be automatically presumed incompetent. In fact, under law, there is a presumption of testamentary capacity unless clear evidence suggests otherwise. Mild dementia does not disqualify someone from executing a valid will, especially if they meet the specific legal and clinical standards outlined by Milton. The key factors to examine when including an individual's cognitive function would be cognitive functioning at the time the will was executed, not before or after, the ability to recall and understand their assets, such as property or finances, and awareness of the people who would normally benefit, such as children or spouse. Understanding the act of making a will and what that document does, coherence and consistency in planning how their estate will be distributed, presence or absence of external pressure, undue influence, any signs of delusional thinking or compromised reasoning. Milton outlines 4 key criteria for testamentary capacity, which is understanding the nature of extents of one's property, knowing the natural objects of one's bounty, such as potential heirs, understanding the nature of the act of making a will, and being able to form a rational plan for distributing property. If the individual satisfies all 4 of these criteria, even if only during a lucid interval, their capacity should be considered valid. The law intentionally sets a low threshold for capacity in testamentary matters to respect autonomy, if decisions are made without cognitive distortion or coercion. In conclusion, a diagnosis of mild dementia alone is insufficient grounds for invalidating a will. The assessment must focus on function, not diagnosis, and Milton's framework provides a structured, fair way to evaluate capacity in these nuanced situations. These are the key references used throughout the presentation, and thank you so much for your attention, and I'm looking forward to the discussion.